that it is undemocratic. Then whereas every benefit he had under the party was undemocratic, which is all undemocratic, he says, as well as of the Rashtriya Karyakarani, and that he had assumed the position of Mukhya Neta under which constitution? Election Commission is only a tribunal, Maharaj. It can't decide the party democratic or undemocratic nature of party constitution. There is no Mukhya Neta under the 1999 constitution. So under which constitution did he, Maharaj, confer himself this title? I was Paksh Pramukh. He says, no, you are not Paksh Pramukh, or even if you are, we throw you out. I am the Mukhya Neta. And I transfer your powers to myself. Under which constitution did he transfer those powers? He is the creature of the same constitution. How does he get the party symbol? And therefore, there was a very heated debate. And Shankaranand was then the law minister, or the home minister who actually took this forward. And the debate said that, look, you should not force a registration of a political party. It's a voluntary organization. But the logic was that every party must take an oath to the Constitution of India. This was the core reason why registration became necessary. This was the only reason for 29A. There is nothing into here to state that you will decide on whether it is democratic or undemocratic. It is completely alien. I'll run my party. It's the way I want it. And whereas those who do not want to be part of it can say, I don't want to join your party. You say you'll join my party. You will take the benefits of everything that's happened after joining my party. And then you say everything was undemocratic. How is all this part of a para 15 dispute? Para 15 assumes that you have been elected or nominated under a particular party constitution, and that there is a split in that original political party. Which rival faction is the party is to be decided. What is the dispute of the democratic or undemocratic constitutions got to do with paragraph 15? Determination that the test of the party constitution is not appropriate to decide the dispute. This is his next finding. Next, both sides moved to the test of the party constitution. The petitioner argued that the test of the constitution of the party could not be relied on in the present case, since the constitution of Shiv Sena, as amended in the year 2018, was undemocratic. This is very important. Now, the other side has argued, having been appointed under the 2018 constitution, and I'll give you judgment after judgment, both of the commission and otherwise, which says that if you have got the benefit of the very constitution under which you were appointed or elected, you cannot challenge that constitution. This is the first time the petitioner takes this position that it is undemocratic. Then whereas every benefit he had under the party was undemocratic, then his election to the legislature was undemocratic, his being a minister was undemocratic. And which subverted inner party democracy. Never raised the voice, right from 2018. Never raised the voice. It was opportunistic and convenient to do so. The learned senior counsel submitted that the original constitution of Shiv Sena was amended in the year 1999 after the commission had written to Uddhav Thackeray and the then president of Shiv Sena to amend the constitution to make it more democratic. However, the changes introduced by Uddhav Thackeray were reversed by the respondent in the year 2018 by making amendments in the party constitution, which gave the power of appointment of most of the party office bearers to the party president. But let's just note the fact, office bearers. And I'll come to that a little later. The party constitution as amended in 18 will yield non-democratic and biased outcomes as its design was changed to curb inter-party democracy and to stifle dissent. Further, it was contended that the said amendment of 2018 was in the teeth of the prevailing instructions of the ECI. Therefore, reliance on such a party constitution was untenable for deciding the present dispute. So the argument was, because it's undemocratic, I may have got the benefit of it, but you can't look at the constitution to decide this dispute. On behalf of so-and-so, it was argued that a rival faction or group emerging within a political party and claiming to be that party under 15 must do so within the framework of the party constitution. But how does he move the commission outside the party constitution?
And he wants the party.
He wants the party, Bharat, this very party, under this constitution. But was in fact appointed by the respondent in exercise of the latter's power provided under the party constitution as the leader of Shiv Sena, and that the petitioner then did not raise any grievance about the party constitution. Moreover, it was submitted that the commission must only consider the constitution of the party which is on record with it, and which was in existence at the time of arising a dispute between rival factions or groups of the party, and therefore in the present case, the petitioner was not acting as per the party constitution, which was on the record of the commission. Shri So-and-so further argued on behalf of the respondent that he enjoys an overwhelming majority in the rank and file of the party, and as per the members who were part of the Pratinidhi Sabha pursuant to the organizational elections in 2018, that the organizational majority test is the test to be applied in the present case, as was done by the commission in KP Unnikrishnan. To substantiate this argument, it was submitted that the petitioner had conducted meetings of the Pratinidhi Sabha, which is all undemocratic, he says, as well as of the Rashtriya Karyakarani, and that he had assumed the position of Mukhya Neta under which constitution? There is no Mukhya Neta under the 1999 constitution. So under which constitution did he, Maharaj, confer himself this title? I was Paksh Pramukh. He says, no, you are not Paksh Pramukh, or even if you are, we throw you out. I am the Mukhya Neta. And I transfer your powers to myself. Under which constitution did he transfer those powers? Not under the 99.
After the defection.
And this is after defection. All this is after defection. 2018 amendment of the party constitution being referred to by both sides needs to be contextualized. This is now what the commission is saying. Shiv Sena party was formed in the year 69. When in 89, section 29A was incorporated in the RPA, the commission facilitated its registration. On the persuasion and advice of the commission, 97-98, party finally amended its constitution to do away with the position of Bala Sahab Thackeray as Shiv Sena Pramukh for life or till he so desires, and with the provisions for nomination of office bearers solely by the Shiv Sena Pramukh. The removal of such clauses allowed the commission to take that amended constitution of Shiv Sena on record. The decision of the commission, both in 89 and thereafter in 97, was in the genre of ongoing and continuous attempts of ECI to mainstream the pre-existing political parties into the framework of newly introduced 29A. In this context, it's relevant to consider that on 16/7/98, the commission directed Chief Electoral Officer Maharashtra to communicate to Shiv Sena and observation of ECI that in a nutshell, the party constitution envisages the president nominating the electoral college, that it is to elect him. This goes against the spirit of democracy and negates the very purpose for which the entire exercise was carried out. In their reply on 29/4, Shiv Sena inter alia made the following specific points. In fact, the electoral college consists of not only of representatives elected by the ordinary members of the party, but also people's representatives, that is Shiv Sena members of parliament and members of the legislative assembly and the legislative council. Thus, the Pratinidhi Sabha is a body with much broader base in a true sense. Commission has always maintained that political parties, being vehicles of different ideologies, must chalk out for themselves their own manner of functioning and embody the same in their constitution. And all that the commission insisted is that persons who act or speak on behalf of the recognized political parties should be elected members of the party, and this should be explicitly put in the party's constitution. During the dispute, both sides had referred to a further amended constitution of 2018. The original amendment was 2013, 2013, then 2018, which is not on record of the commission. In this context, it is critical to refer to conditions of registration of Shiv Sena party as communicated to the Election Commission on order dated 19/10/89, inter alia, stipulating in para 2 the statutory requirement under 29A as provided in the Representation of People's Act. The party shall communicate to the commission without delay any change in its name, head office, office bearers, or any other material matter. Further, the guidelines of the ECI, now note that these guidelines came into effect in 2010. Exercise of in exercise of powers conferred under Article 324 and 29A of the Representation of Peoples Act specifically provide that each constitution carries a clause for amending the constitution, which of course it was in our constitution, both 99 and this one. The applicant party must submit authenticated proof to show that the party constitution has been adopted by the general body. The applicant party must ensure in this constitution itself, via a specific clause in the party constitution, that any amendment to the party constitution must be approved by the general body. I'm just making a comment here, just note it. How is this part of the para 15 dispute? How is all this part of a para 15 dispute? Para 15 assumes that you have been elected or nominated under a particular party constitution, and that there is a split in that original political party, which rival faction is the party is to be decided. What is the dispute of the democratic or undemocratic constitutions got to do with paragraph 15? It's wholly alien, wholly irrelevant. Election Commission is only a tribunal, Maharaj. It can't decide the party, democratic or undemocratic nature of party constitutions. And I'll assume, Maharaj, I'll assume for the moment that my party is constitution undemocratic. Maharaj, your Lordship asked me two questions. What is your defense in law? And how do you prove that your party was democratic in fact? And I'm going to answer both, Maharaj. But I'll assume for a moment that this is an undemocratic constitution. So what's the consequence? Consequence is deregistration. There is no other power.
Not to give the party symbol to them.
But it doesn't allow the party symbol to go to them. He is the creature of the same constitution. How does he get the party symbol? One, it's alien to 15. Two, the benefit can't go to him. And three, what power does the commission have to decide this issue? Assuming it has that power and declares me undemocratic, what is the consequence of that? Consequence of that is a notice to me to re-register. Nothing more. 29A doesn't give him that power. Now, let us kindly have a look at 20. I'll just pause for a minute. Go to 29A of the Representation of Peoples. Yes, there's a statute compilation also, Madan. We can hand over. Just give it to my lord. We actually have a statute compilation. Easy for your lordship. Give it to my lord. Give me also.
Section 59 of.
Madan, I'm giving your lordships a whole compilation of all the statutes so that, Madan, it's easier for your lordship. 1951 RP Act, Madan.
59 is special provision in the case of second election.
Yes, kindly now see. It's very important. Any association or body of individual citizens of India, calling itself a political party and intending to avail itself of the provisions of this part, shall make an application to the Commission for its registration as a political party. Maharaj, let me tell your lordships the background. Maharaj, prior to 29A being incorporated, there was only the symbols order. And under the symbols order, you had to apply, the political party had to apply to get a symbol. So when the issue of 29A was debated in Parliament, several contentions were raised. Why do you need this? Because ultimately it is for the symbol. And under the symbols order, you will get a symbol when you apply. You don't need registration. Why are you regulating a political party? Because political party is a voluntary organization. So why should you regulate a voluntary organization? And therefore, there was a very heated debate. And Shankaranand was then the law minister, or the home minister who actually took this forward. And the debate said that, look, you should not force a registration of a political party. It's a voluntary organization. But the logic was that every party must take an oath to the Constitution of India. They said we can't have a political outfit whose objectives are inconsistent with our basic values under the Constitution. And therefore, registration is necessary.
Religious to the court.
That's right. That was the core reason why 29A was put in. Now, if you read 29A, you will find that there. So every such application shall be made if the association or body is in existence at the commencement of the Representation of People's Act, because this was amended in later, within 60 days next following such commencement. So if you have a political party and have a symbol, then you must make this application. If the association or body is formed after such commencement, within 30 days next following the date of its formation. Every application under subsection 1 shall be signed by the Chief Executive Officer of the association or body, whether such Chief Executive Officer is known as Secretary or by any other designation, and presented to the Secretary to the Commission or sent to such Secretary by a registered post. Every such application contain the following particulars. Note that, Mullahs. The name of the association or body, the state in which its head office is situated, the address to which letters and other communications meant for it should be sent, the names of its president, secretary, treasurer, and other office bearers, the numerical strength of its members, and if there are categories of its members, the numerical strength of each category, whether it has any local limits, if so, at what levels, whether it is represented by any member or members of either House of Parliament or of any state legislature, if so, the number of such member or members. The application under subsection 1 shall be accompanied by a copy of the memorandum or rules and regulations of the association or body, by whatever name called, and such memorandum or rules and regulations shall contain a specific provision that the association or body shall bear true faith and allegiance to the Constitution of India as by law established, and to the principles of socialism, secularism, and democracy, and would uphold the sovereignty, unity, and integrity of India. This was the core reason why registration became necessary. This was the only reason for 29A. There is nothing into here to state that you will decide on whether it is democratic or undemocratic. It is completely alien. Now, the Commission may call for such other particulars as it may deem fit from the association or body. Right? So the Commission has the right to ask for other particulars.
At the time of registration.
And that's at the time of registration, no, not later. Not later. Then see, after considering all the particulars, as aforesaid in its possession, and any other necessary and relevant factors, and after giving the representatives of the association or body reasonable opportunity of being heard, the Commission shall decide either to register the association or body as a political party for the purpose of this part, or not to register it, and the Commission shall communicate its decision to the association or body, provided that no association or body shall be registered as a political party under this subsection unless the memorandum or rules and regulations of such association or body conform to the provisions of subsection 5. The decision of the Commission shall be final. And then 9 says, after an association or body has been registered as a political party. Now there's a rationale for 9. As aforesaid, any change in its name, that is 29(4), head office, office bearers, address, or in any other material matters shall be communicated to the Commission without delay. Now, I ask myself this question: where is the occasion for the Commission to decide under 29A? That's not its statutory power.
Amendment to the party constitution will not be included in any other material.
It's been clarified by Shankaranand in the debate itself. Those other particulars must relate back. There's not some omnibus clause that you can ask for anything, or that there's a duty.
No, amendment to the original party constitution, will it not come within any other material matter?
Maharaj, this is the point that has not been clarified. This question was asked in the debates, and I'll show your lordship that debate. He said, don't please interpret any other particulars in this fashion. Maharaj, I'll tell your lordship the rationale for it. What's the rationale? The rationale is that you must adhere to the principles of socialism and other facts, Maharaj. That's all that is required. Maharaj, I've been in this business for more than 35 years now, Maharaj. Kindly see, I appoint the secretary to the organization. Has he to be elected? I take a decision in the working committee that you people go ahead and execute this. As that person who is the Youth Congress president, is he to be elected? I'll run my party. It's the way I want it. And those who do not want to be part of it can say, I don't want to join your party. You say you'll join my party. You will take the benefits of everything that's happened after joining my party, and then you say everything was undemocratic. I can understand the Election Commission getting to know something egregious that has happened. You can understand that. Normal is what happened. Now, there is no change in the statute. But in 2010, there were guidelines framed by the Commission. Guidelines framed by the Commission, not part of the statute, which required at the time of registration. Now, let's kindly have a look at so that your lordship is clear on the. Just it's part of the compilation. The statute compilation. It doesn't matter, I'll tell you. Right.
माननीय सुप्रीम कोर्ट की इस सुनवाई ने यह साफ कर दिया कि यह लड़ाई सिर्फ दो नेताओं की नहीं बल्कि भारत के संविधान और लोकतंत्र के नियमों की है। अगर हम इस पूरे केस को आसान शब्दों में समझें तो यहाँ दो सबसे बड़े कानूनी सवाल हैं। पहला, क्या कुछ विधायकों या सांसदों का पाला बदल लेना ही पूरी राजनीतिक पार्टी का बंटवारा माना जा सकता है? दूसरा, क्या चुनाव आयोग सिर्फ निर्वाचित सदस्यों की संख्या गिनकर किसी को भी असली पार्टी घोषित कर सकता है? उद्धव ठाकरे गुट का तर्क है कि पार्टी का संगठन और पार्टी के कार्यकर्ता ही असली ताकत होते हैं। वही शिंदे गुट का मानना कि लोकतंत्र में चुने हुए जनप्रतिनिधियों का बहुमत सबसे ऊपर होता है। माननीय सुप्रीम कोर्ट की विशेष पीठ अब इसी कानूनी उलझन को सुलझाने में लगी है। दोस्तों, आपका इस बारे में क्या कहना? अपनी कीमती राय कमेंट्स बॉक्स में जरूर साझा करें। जय हिंद दोस्तों।